Welcome to Mastering and Contracts lecture. First, we are discuss the means of contracts. That is very important topic, means of contracts, because if you want to understand the contracts, is must to know about the contracts, right? We start with that. Definition of contracts. A contract is a legally binding agreement between two or more parties that obligates them to perform certain actions or refrain from certain activities. Contracts can be oral or written, but for clarity and enforceability, written contracts are typically preferred. Key elements of contract include mutual consent, it is offer and expect acceptances, then legal purpose, then capable parties, and consideration means something of value exchange. And contracts serve to define the rights and responsibilities of the involved parties and provide a framework for resolving disputes if they arises. Next is offer and acceptance. These points are the characteristics that key points which are exactly needed in the contracts wherever we starting the drafting of contracts. These points are very necessary. Yeah, the considerations is also must necessary, and without offer and acceptance there is no any contracts. We start moving towards the offer and acceptance. A contract, it's begin with one party making an offer to another. The offers set out the terms under which the offering party is willing to enter into the agreement, and the other party must accept the offer without any material changes for a contract to be formed. If one party offers something for the another party and another party accept that offer of the one party, then it is make a one type of contract, right? I hope you all are understanding this point. Next is consideration. This refers to something of value that is exchanged between the parties. It could be money, it could be goods, it could be services, promises to perform certain actions, or refraining from doing something. Consideration is a crucial because it signifies that each party is giving something up or sacrificing something in exchange for the benefits of the contract. It is very important topic, consideration. I think it's very easy for understanding. If you give something to another person and another person gives something to you as a consideration. For example, you have some your intellectual property rights, so you have a trademark for your brand. If you want to sell your brand, you want to sell your brand to another person, you should also sell the trademark of that brand to another person as well, right? So after that you just start the one type of agreement and trademark, particularly the TMP form, and you just file them because for the transfer of owner, right? So you just here you just confirm one type of amounts like 5,000, 50,000, 5 lakhs. That is the price is said, it's known as a consideration. If you have any promises to action, I kept your store healthy and I will doing all activities behalf of you. So that is also consideration. And services any you are providing to them, that is also consideration. And goods, like example in franchisee agreement, you give franchisee to another person, they're selling your goods for behalf of you in that shop, okay? So that is also one type of consideration. Moving towards the next point is legal capacity. For a contract to be enforceable, all parties involved must have the legal capacity to enter into an agreement, and this generally means they must be of a legal age. Legal age is 18 years old in many jurisdiction. I think 18 years or 18 years old is a legal age in a majority of the countries. and mentally competent, not under the influence of drugs or alcohols when entering into contract. So that is the legal capacity, legal criteria. Now you are eligible for the contract, entering into contract. If you are not 18 years old, if you are not mentally competent, if you are under the influence of drugs and alcohols, so this generally means they must be not go to the entering into contracts. Next is legal purpose. So legal purpose of the contract, it must be lawful. Contracts with illegal objectives or that it's violate public policy are not enforceable. Any public policy are enforced by the violated by the enforcement of contract. Any illegal objectives, misleading, mischief with the contracts, with the type of points are mentioned in the contracts, then the contract is not lawful. Next is mutual consent, also known as meeting of the minds. And mutual consent means that all parties must understand and agree to the terms of the contract, it's willingly and without coercion or under influence. Next is our types of contracts. Express contracts. So first is express contracts. What is express contracts? So these are explicitly agreed upon either orally or in writing with all terms explicitly stated. That means all terms in the contracts are explicitly stated, like no one are implied terms, right, in the contract. So some any examples like a governing law should be this in the future. So this is the explicitly terms and this is the explicitly clause in the contract. Next is implied contracts. So these contracts are inferred from the actions and conduct or circumstances of the parties involved rather than the being explicitly stated. So this type of contracts are implied in the nature. So there the parties is involved in this contracts rather than is explicitly stated. Next is bilateral contracts. So both parties exchange promises to perform a certain actions. For example, in a sales contracts, the buyer promises to pay, right, and the seller promises to deliver the goods. It is a very best example, I think, for understanding the bilateral contracts. Next is unilateral contracts. In this type of contracts, one party makes a promises in exchange for the performance of an act by the other party. So for instance, a reward offer is a unilateral contract where the reward is given in exchange for performing a specific task. Okay, you have a one specific task, and if you completed this on time, then you get a reward from that any particular coach, right? So this is the unilateral contract. Moving towards the next part is adhesion contracts. That means these are standard form contracts drafted by one party, often a business, and presented to the other party on take it or leave it. If you are agree, then take it. If you are not agree, then leave it. So this is basic term, and these terms are usually non-negotiable and favor the drafting party. So this is one type of we can take example here, terms and policy of any application of any company, then refund policies. These are the adhesion contracts. The next is aleatory contracts. Contracts where the performance or outcome depends on the uncertain events, such as insurance contracts, where the payout depends on the occurrence of the specific event, right, like fire, accident and death. Next is executed versus executory contracts. So an executed contracts is one where both the parties have fulfilled their obligations, and executory contracts is one where one of the parties, one or the both parties have obligations that are yet to be fulfilled. So this is very simple definition for this. I think it's also easy for understanding, right? Next is valid contracts. Valid contracts meet all the legal requirements for enforceability. They include all necessary elements such as offer, acceptance, considerations, legal capacity of parties, and legal purpose. If the contract is binding and mention all types of necessary elements, then it is make a valid contract, right? Next is void contracts. Void contracts are agreements that are not enforceable from the outset because they lack essential elements. For example, contracts with illegal purpose or involving parties without legal capacity are considered void. Next is voidable contracts. They are not void, but it is voidable. So voidable contracts are valid contracts that can be voided or cancelled at the option of one of the parties due to certain legal reasons such as fraud, then undue influences or lack of capacity. So this is not a void, but later on it is chances to get a voidable contracts if they are not fulfill the legal reasons, right? So this is all for our lectures. It is meaning of the contracts and types of the contracts we learn in this. If you have any questions, you can also ask me. And yeah, we have some negotiating answer and question session in last in last after that all the lectures. So yeah, please make a notes from them. Thank you so much for listening me, and I hope you all are understanding these points very well.